Force majeure, what is it? What do I need to know? Hi, my name's David Richards. I'm a litigation solicitor at Butcher Andrews, specialising in construction law. Hopefully most people are working from home and socially distancing, but of course business goes on as usual, and sadly there have been several cases that I've certainly seen, and presumably up and down the country, where parties are disagreeing about their commercial agreements and what to do about them given the current pandemic and the government restrictions. One of the things that people may be arguing about is how to get out of a contract or get an extension of time, and one of the ways that parties can do that is through a force majeure clause. So what is force majeure? It's Latin for superior force. It simply means that something unexpected and out of the ordinary has happened, and therefore unusual consequences should follow. Often in a contract, force majeure will be defined, so it'll say act of God, strike, pandemic, war, words to that effect. In other contracts it isn't. So for example, in the JCT construction contract, it isn't defined at all unless you've got bespoke amendments. There isn't any judicial interpretation of the JCT words force majeure yet. There is a case from 1920 called the Baupin against Crispin, and in that case the court defined it as all circumstances independent of the will of man, which it is not in his power to control. Thus war, inundations and epidemics are cases of force majeure, so it appears to be covered by the common law definition. If there's a general catch-all bit of the definition, then that needs to be read in light of the preceding bit. So that if it says act of God, war, pandemic, and other events beyond the reasonable control of the parties, then it doesn't mean any events beyond the reasonable control of the parties. It means events that are similar to the preceding bit. So, for example, there's a case called Tandrin Aviation Holdings against Aero Toy Store from 2010. Where the financial crash was argued to be a force majeure event, but the court rejected that. Although it might not have been foreseeable to the parties, it wasn't of the nature of the other bits of that clause that had defined force majeure. Act of God, as I said, is often in the list. There is a definition from the court from 1876, a case called Nugent against Smith, but the definition is a direct and violent and sudden and irresistible act of nature. And of course that wouldn't include pandemic. It's not violent, it's not sudden. So there is scope for argument that if the force majeure simply says act of God, then it doesn't include the pandemic, though it's a very old case. If it needed to be argued, no doubt it could be. Don't assume that the courts will be automatically sympathetic, by the way, because this is an unprecedented and obviously very sad time for a lot of people. There's a case called Metropolitan Water Board against Dick Care from 1918, where the contract said that the effectively a force majeure type clause would be triggered by delays whatsoever and howsoever occurred. So whatsoever and howsoever occurred, and the court found that World War I was not covered by that clause because of the other wording in the contract. So don't assume that the court will automatically take your side and be sympathetic. The other thing to say is that there's a presumption in a force majeure clause that the event has to be unforeseeable. So if you've entered into a contract in March 2010, then it's likely that the court will say, well, I'm sorry, but you knew about COVID-19 at that stage, and therefore it's foreseeable, so it's not a force majeure event. Whereas if you went into the contract last August, then that's different. It obviously wouldn't have been foreseeable for you. There's notice provisions are often in the contract, and if the contract says you've got to give notice on pink paper by pigeon, then put it on pink paper by pigeon. Some contracts will say that a force majeure event has to hinder or impede the works, and if that's the case, then it's relatively easy to prove that the triggering event has caused that problem. Sometimes, though, the contract says that the works have to be prevented, and prevention can be very hard to prove in this context. The courts can be very strict about force majeure events. So, for example, a case called Seadrill Ghana against Tullow Ghana. the whole purpose of the contract was for drilling, and the Ghana government imposed a moratorium on drilling. The courts found that although the event was a force majeure event, the parties were unable to rely on it because the force majeure event was not the only cause of the delay or the impossibility for that period of time. So be careful, be cautious when invoking a force majeure event, and know that the court is like I say, going to take a restrictive approach. In terms of the consequences, sometimes the contract says that a force majeure clause will allow an extension of time, and that's the most common consequence. Sometimes they'll allow loss and damage, and sometimes they'll allow parties to terminate, and it's all about the wording of the contract. And that's about it for force majeure. Any questions, give me a call. Contact details are on LinkedIn. It's David Richards at Butcher Andrews. Keep safe. Thank you.